Assalamualaikum warahmatullahi ta'ala wabarakatuh. We will continue with our lecture. This is the repetition of our online lecture earlier. Okay. Before I proceed further, I would like to share with you that all my slides while my lecture, sometimes I took the information from internet, the images from internet, like picture, video, okay. All the copyrights of those materials remains with the owner of the material. Okay, either it's lecture, the notes, the picture, or whatever that I actually included in my slides. This is for education purpose, not more than that. And the purpose of these slides is to assist my students, and I do not allow you, and you have no rights to upload the slides, the video in any websites, okay, in any websites. And this rule applies to all my lectures and all my slides. So please do not upload anywhere because it's belong to many people, the ownership. Thank you. So we'll proceed with our lecture today. Once a company is formed, the company need capital to proceed with the business, to conduct business so that they can get the profit. Okay. How can a company get capital? So the company get their capital through issuing of shares, right? Once the persons purchase the shares of the company, these persons become the shareholders. From the money that they got from the shareholders, this money is the capital. They will conduct their business. Okay. So this fund, the money received, okay, is called share capital. What is share? So we will look to the explanation in the case of Bolland's Trustee and Steel Brothers and Company Limited. Share represent the interest of the shareholders in the company. Shares is measured by sum of money. So what is share? Share is a interest of the shareholders in the company, which is measured by money. Okay, the more the shareholders have in the company, the more the power the shareholders got, right? What does it mean by power, right? Power in the sense of participation in decision making through voting. For example, the shareholders, okay, through the shares they have, they got the right of voting. So how does they participate in decision making? Because shareholder vote in appointing directors, removing directors, appointment of auditors, or removal of auditors. Okay, so participation of shareholders is important. It shows what they decide for future, who they want to run the company. So this is how the shareholders participate, in decision making. The shareholders, they could sell their shares to other person. Once you purchase a share of a company, unless it's stated otherwise from the very beginning by the constitution of the company, the shareholders could sell their share to any other persons, right? So it's not like once you become a shareholder of a company, you will be forever shareholder of the company, as I said earlier, unless stated otherwise. Okay. Power to allot and issue shares, first time, at the first instance when the company was being incorporated, it was the promoters who decided how much shares needed by the company, because the promoters were the one who actually incorporated the company. But that much of shares may be later on be increased or decreased by the board of directors. Once a company be incorporated, the next step is the company will form the board of directors. This board of directors are the directors who decide what to do with the company, how to run the business of the company. So they would know whether the company need more capital to run the business. If the board of directors decide to increase the amount of share capitals, they can do so. Okay, because they know if the company required more capital to run the business. Okay. However, we have to bear in mind that the directors, they do not have absolute powers in issuing shares, right? The issuance of shares shall be approved by shareholders in meeting, right? Even though they have the right to decide, like, we need more capital, we need more share, we have to issue more shares, but they cannot simply issue shares. They need approval from the shareholders. Even though the directors has the right to decide what to do with the business, how to do, but shareholders are always there. The directors have, in some matters prescribed by laws, to refer to the shareholders before they proceed, especially when it involves something very important with the company, for example, shares. Okay. In Section 75, subsection 1 of the Companies Act, it is provided that the directors need the approval of the shareholders in 4 situations. The first one is when the director decided to allot shares. They need to get approval from the shareholders. Second, when the directors want to grant rights to subscribers for the shares. Third, when the directors want to convert any security into shares of the company. Okay? And number 4, when the directors want to allot shares under an agreement or option or offer. Okay, all these 4, before the director proceed with all these 4 action, they have to get approval from the shareholders. Okay. If the director does not comply with the above provision, that is share the above shares without issue the above shares without the approval of the shareholders, the directors would be liable under Section 588 subsection 2, in which it is stated that the director shall be fined not exceeding of ringgit Malaysia 50,000 or imprisonment for a term not exceeding 3 years or both. As I said earlier, that directors need approval from shareholders before the directors can issue shares. Why is that so? This is because the moment the company or directors issue more shares, the existing shareholders' power is reduced somehow. Okay, let us go for an illustration or example. Let's say Mr. Jamil is holding 60 shares out of 100 shares in company XYZ. Now the company, now he is the majority shareholders. He holds the majority shares in the company. Definitely, he has the power to say something in the company, isn't it? So now, the company and the directors decided to issue more shares. They want to issue 500 shares more, right? And they issued the shares, all right. After the issuance of the shares, what would happen to Mr. Jamil? Right. Previously, he was holding 60% of the shares of the company XYZ. Now, after the issuance of the shares, he holds 60 shares out of 600 shares. All right. From 60% reduced to 10%. He is not holding the majority shares anymore. Right. You see, in some cases, the directors could issue more shares with a bad intention to reduce the voting power of the existing shareholders. So this kind of situation can be avoided if the directors, the law did not allow the directors to issue shares without getting approval from the shareholders. Okay, this can be avoided when the law require the directors to get approval from the shareholders before they issue new shares. In discussing approval from shareholders for the directors to issue new shares, we will refer to the case of Coco Tavich Construction and Wallington. Okay, because you see, I said that some directors somehow they have bad intention in issuing shares. They want to reduce the power of the shareholders. So the best case to illustrate what I've said earlier is this case, Coco Tavich Construction and Wallington. All right. The main discussion or the point of this case is the operation in reducing the voting rights. Okay, basically the company did operation to reduce the voting rights of one of the shareholders. Okay, in this case, okay, there were two shareholders for Coco Tavich Construction. There were two shareholders. The first one is Coco Tavich himself, and second one is Wallington. Okay, two shareholders. Coco Tavich was the directors and also shareholders, while Wallington only shareholders. Okay. In this case, at first when they incorporated the company, they had a very good relationship. After some time, the relationship became bad, and Coco Tavich, he wanted to reduce the power of Wallington by reducing the rights of Wallington. How can he did that? How can he do that? Okay, by issuing new additional share to himself. Right? So he issued additional shares to himself to reduce Wallington's voting rights. Now he became the majority shareholders. Definitely he has more powers in making decisions. And Wallington now does not has as much as power as before because his shares has been reduced. Okay, so now Wallington sued Coco Tavich Construction for operation. Yeah, and the court in this case agreed with Wallington that there was oppression against Wallington. Okay, why? Because Coco Tavich in this case, when he decided to issue more shares, he had a bad intention. His intention was to reduce the voting rights of Wallington, and that's what he did. All right. So the court says that he had a bad intention, and his action issuing additional shares to himself and reducing the voting rights of Wallington was done in a bad faith and a bad motive, and this is considered as oppression. Okay, so what happened to the action? Of course, the action is not valid because it was done by oppression. Okay. We have some exception, yeah, exception for directors where the directors need not to obtain shareholders approval in issuing shares. There are some situation where the law allow the directors to basically issue shares without getting approval from the shareholders. This is in pursuant to Section 75, subsection 2 of the Companies Act. Please refer to your Companies Act. Okay. The first situation is this, where the shares are allotted or rights are granted to the existing shareholders in proportion to their shareholdings. Okay. Second, the shares are allotted or rights are granted to existing shareholders under a bonus in issue in proportion to their holdings. Okay. And number three, the shares allotted to a promoter, which the promoter has agreed to take. And number four, the shares are issued as a consideration for the acquisition of the shares of the shareholders by company. These four issuance of shares or allotment of shares, when it happens, the directors need not to obtain the shareholders' approval. They can simply proceed by the issuance of shares in these four situations. Right, now we go for the mechanism of share issuance. Okay, first of all, what does it mean by allotment? Allotment indicates that the director decides the amount and type of shares that will be issued, and later on the director takes steps to issue the shares. Okay. Next, the prospective shareholders is informed that his application is successful, right? And the number of shares allotted to him. When the shares allotted to the shareholders and the shareholders subscribe to the shares, there's allotment and the shareholders subscribe, okay? It will confer on the shareholders the right to have the shares registered in his name in the register of member. The issuance of shares takes place after the allotted shares are taken by the subscriber, and these shares are then registered in the subscriber's name. This is provided under Section 76, subsection 5 of the Companies Act. Okay, how long the company can take time to register the name in the registry, the subscriber's name in the registry. The company must do this within 14 days from the date of allotment. Okay. If the company did not do this within 14 days, there will be criminal liability on the company and every officer who actually contravene to this section. So it must be done within 14 days to register the subscriber's name in the registry. Okay. And this is provided under Section 77 of the Companies Act. Right. Company must also lodge with the Registrar of Companies a return of allotment of shares in the prescribed form. Right. This is the mechanism. So now under the new amended Companies Act 2016, there will be no par value. Under the previous law, we do have the company must set par value for shares, right? So under the Companies Act 2016, we don't have this. Okay. What is par value? Just for the sake of knowledge, alright? Par value basically is the minimum amount that is represented by one share for issuance, right? Usually the par value is inserted in constitution of the company and the director would put the lowest value. For example, one share is RM1. So under the letters, the amended Companies Act 2016, we don't have this, okay? The share issued by the company shall not necessarily must be according to the par value, right? If in an no par value environment, the shares are number of par value environment, the shares are issued at the price to be determined by the directors. Okay, the shares are now determined by the directors. So we have no par value regime under Companies Act 2016. Under this one, the price of the share will be determined by who? By the directors. Now we go for type of shares, right? So you know why we have different shares? Because different shares, type of shares have different privileges, different rights, and also benefit to the shareholders, right? So a company may issue ordinary shares or preference shares. It's up to the company what kind of share the company wants to issue. So we have ordinary and preference shares, right? This most common type of shares issued. Section 2 refer to equity share. You have to please open your Companies Act and look at Section 2, equity shares. Equity shares here is defined as any share which is not a preference share, alright? So the Companies Act did not actually define ordinary shares, but the Companies Act under Section 2 define equity shares by stating that any share which is not a preference share, right? So this is usually understood as ordinary share, right? The shareholders with ordinary shares would have the right to vote. This is also provided under Section 2, right? Section 2 further define preference shares. Go down there and look at your act, Section 2. See, under P, preference shares. Okay. What is preference shares? It's a share by whatever name called. You can call it whatever, which does not entitle the holder the right to vote. I bold here. Not entitled the holder to the right to vote or to participate beyond a specific amount in distribution of dividend. Okay, for preference share, if you promise this specific dividend, only that specific dividend is allowed, right? Or on redemption in a winding up or otherwise. Now, why does a company issue preference share? Do you know? Right. You see, companies sometimes require more capital from shareholders or investors, all right? They want to expand their business. You know that shares are the capital of the company. The money that they got by selling shares, that is the capital of the company. When the company want to expand, they need more monies. They need more capital, share capital. So what they do, right? Rather than they issue ordinary shares, and then reduce the power of the existing shareholders. What the company do, they issue preference shares, right? That you know, right? We discussed already that preference shares holder, they have no right to vote, all right? But they have the right to dividend. Of course, when you purchase shares, you want something back. What kind of benefit you can get. So being a preference shareholders, you can get dividend or other things, but you cannot vote, right? So now companies require more capital, all right? So in expanding their business, so the companies issue preference shares. And you see one of the reason perhaps, all right, by issuing new ordinary shares, all right, the companies, the directors are inviting new person to be the shareholders. They can have more person to be shareholders. Rather than having, for example, 7 shareholders now, they issue new ordinary shares and 5 more person actually come and join the company, or 10 more person come and join the company under the name of shareholders holding the ordinary shares, all right? So the director actually, scared that they might be replaced. When you have more shareholders, new shareholders, these new shareholders might have someone in their mind to be appointed as the directors to run the business of the company, right? So not necessarily when we have new shareholders, they will maintain the existing directors in the board of directors. They might appoint new directors who they have trust with to run the business of the company. Why? Because they are the shareholders. They are putting their money in the company. They put much money in the company. Of course, they want profit. So, of course, they will appoint someone that they believe can run the business better. Okay? The issuance of preference shares also would prevent the existing director from being removed. So now if they issue preference shares have no right to vote. So preference shareholders have no right to vote. So preference shareholders have no benefit of actually join in appointing directors or, appointing accountant. They don't have this privilege. Okay. So the issuance of preference share would prevent the existing directors from being removed, as the preference shareholders cannot vote in meeting. So this might be perhaps the reason why companies issue preference shares. Rights of ordinary shareholders. The rights of ordinary shareholders is provided under Section 71 of the Companies Act. Okay, it is mentioned here that shareholders other than preference shareholders have the following rights. They have the right to attend, participate, and speak at meetings, right to vote on a show of hands, right to vote on a poll, right to the distribution of the surplus asset of the company, and right to dividend. Preference shares. Now we discuss a bit on preference shares. You see, before a company can issue preference shares, the directors must make sure that the constitution of the company allow the company to issue preference shares. Okay, this is provided under section 90 subsection 4 of Companies Act. If the constitution of the companies did not allow the company to issue preference shares, the company cannot do so. They can only do if it is allowed. All right. If the company wishes to issue preference shares, the constitution of the company must contain. That's why before the company proceed, they have to check their constitution. Is the constitution of the company allow? Because if the constitution of the company allow the company to issue preference share, the constitution must mention the details of the right of the preference shares. Okay. It is a must. It's not just the constitution allow the company to issue preference share, but the constitution must also provide the details of the right of the preference share. For example, here I share with you first to repayment of capital. Okay. Second, participation in surplus asset or profit. Okay, can they participate, or whether they can participate with the profit or they cannot, whether the preference share is intended to be a cumulative or non-cumulative, whether the preference shareholders is intended to be given cumulative or non-cumulative dividends, and whether they have voting rights, and parity of payment of capital and dividends in relation to other shares or classes or preference shares. All these details must be included in the constitution. Okay. If the constitution does not specify the rights of the preference shares, but the company just proceed with it, this would be an offence as provided under section 90 subsection 5. So it's not just approval from the constitution allowing the company to proceed with the issuance of preference share, but it must come together with the right of the preference shareholders. Okay. Now, cancellation of preference shares. Okay. Now, preference shares is needed when the company really need money, they need capital, they want to expand their business. Now, the company does not no longer need the preference shares. Okay. So the company now would like to cancel the preference shares and return the capital to the shareholders invested by the preference shareholders. Okay. This is allowed by section 95 of the Companies Act. Okay, cancellation of preference shares. Other type of shares, we have redeemable preference shares, right? And these redeemable preference shares only allow if the constitution of the company allow the company to issue redeemable preference shares as provided by section 72 subsection 2 of the Companies Act. Okay. All right. What does it mean by redeemable? You know that the preference share shall be redeemed later on, all right, from the shareholders in the future. What the shareholders get in return, the shareholders will get compensation. What kind of compensation? The compensation in form of proceeds from fresh issue of shares, profits or capital of the company. Only from these three sources. Yeah. If the company want to redeem the preference shares, they have to pay the compensation to the shareholders from these three sources only. Convertible preference shares, the preference shares that can be converted into ordinary shares, all right? This also must be allowed by constitution. Irredeemable convertible preference shares, the preference shares that cannot be redeemed but can only be converted usually into ordinary shares. Variation or amendment of class right. variation of class right. What does it mean by variation of class right? It means that the company actually vary the right of a class of shareholders. Okay, every share has its own right attached to it, right? For example, ordinary shareholders. You mentioned in your constitution that the ordinary shareholders will get dividend regardless. Okay, so now it becomes the ordinary shareholders' right to dividend, for example. Now the company want to take up this right from all the ordinary shareholders, this right of dividend. So this is called as variation. Okay, you see, let's go to this slide. All right, the rights typically, okay, now we said that share has its own right attached to it. Right, for example, ordinary shareholders has voting right, while the preference shareholder has no voting right. Right. However, this right attached to the share could be amended by the company. Right. For example, now a company want to remove the voting right of ordinary shareholders. Right. So this is what we call as variation of class rights. Right. This is just example. How to vary or change the right of shares? Okay, there are procedures in doing so. All right, there are procedures to vary the right of shares. Okay, it is provided under Section 92 of the Companies Act. Right. However, if a company has a constitution and the company already has its own procedure in the constitution to vary class rights, this is allowed and the company do not need to follow Section 91. Section 92. Okay. The authority of the company to proceed with its own procedure for variation under its constitution is Section 91, subsection 1, subsection A. Right. It is provided that the procedure in constitution of a company prevails over the statutory procedure. Now, what if a company do not has any constitution or did not mention the procedure for variation of class rights of shares under its constitution? The company has nothing in the constitution. The company has to follow Section 92. All right, Section 92 must be followed by a company who do not has its own procedure for variation under its constitution. Okay, if the company has, then the company follow its own constitution, its own procedures. Okay, what's the procedures for varying class right in Companies Act 2016? Right. It's stated here that the proposal to vary the rights of shares need the consent of 75% from the concerned shareholders. Alright, now we have an example here. If the company wants to remove the voting right of the ordinary shareholders, for example, alright, the company must obtain consent from 75% from all the ordinary shareholders. Right, that's what it means by consent of 75% from the concerned shareholders. Right, from the concerned shareholders. Right. The consent could be obtained through writing or voting in a separate meeting among all the concerned shareholders. Okay, it can also be obtained through writing or voting in separate meeting. I have a question here. Is the issuance of new ordinary share is a variation? Alright. Because why we ask this question? Because we say that, alright, variation means we change the right of the shareholders, right? Okay. Now, the issuance of new ordinary share might reduce the voting power of the existing shareholders. So, does it consider as variation? Okay. Although the issuance of new shareholders might reduce the voting power of the existing shareholders, the law does not regard it as a form of variation of the rights of the existing shareholders. Because why? We did not take their rights. The right is still intact. They still can exercise the power of voting. Okay, variation means you take the rights, the whole rights from the shareholders. Okay, that's what it means by variation. Issuance of new ordinary share is not a variation. This is what decided in Greenhall and Ardeen Cinemas Limited. Okay, what happened was the company in this case issued new ordinary shares. All right, so the existing ordinary shareholders at that time challenged the issuance of the new shares. They said that by the issuance of these new shares, okay, all right, the company is varying their rights without their consent. Okay, so one of the issue in this case was whether the issuance of the ordinary shareholders, uh, issuance of the ordinary shares considered as the variation of shares. Okay, the issue was whether the issuance of the ordinary share was considered as the variation of the shares. So the court held that the issuance of ordinary shares was not considered as the variation of shares. Right, we go for the case of White and Bristol Aeroplane. It was held that the issue of new shares other than preference shares is not a variation because although the voting power may be reduced, the existing shareholders still enjoy the same voting rights. Variation means not to reduce the power of the rights. Variation means taking the rights. Okay, taking the rights forever. For example, as I stated earlier, all right, we have two groups, preference shareholders and also ordinary shareholders. The company decided to take the right of voting of the ordinary shareholders. Okay, when the company want to take the right from the group of the shareholders, all right, the group of ordinary shareholders, this is variation because taking the right forever. Issuance of shares means they still have the rights, so it is not variation. Can the variation be challenged under section 93? The variation can be challenged by the concerned shareholders. Okay, how can the concerned shareholders challenge the variation? So they can go to court. Yeah, they can go to court within 30 days after the variation is made. And who can do this? Any shareholders who representing 10% of the concerned shareholders. All right. And for example, I would like to use the ordinary shareholders of company ABC. The company decided to take their rights of voting. So now the company said ordinary shareholders has no right to vote at all. And these shareholders is not happy with the variation. They want to challenge. They can go to court within 30 days. Okay, any shareholder representing 10%. If one shareholder does not represent 10%, it's okay. Join with another one. So it's not 10% yet. Join with another ones also. So now three ordinary shareholders is not happy with the variation of taking their rights, all right, whom the right have been varied, they can go to court and challenge the variation. Okay. So this is how variation can be challenged. You must understand. It's not just amend their right. Okay. Reduce of right to vote. It's not variation. Variation means taking the right to change the whole rights of the groups. Grounds to challenge variation. What are the grounds? All right. First, the company did not follow procedures to vary class rights. Okay, for example, the company does not get consent from 75% of the concerned shareholders. Right. Second, voting was conducted not in the best interest of the class as a whole. All right. The company want to vary the rights, but it is just for benefit of one or two person. not the class of a whole. So this can be the ground to challenge variation at the court. We have British American Nickel Corporation. Okay, the company basically in this case varied the right of the debentures holders, right, in which the variation was agreed and voted by 75% of the concerned debenture holders, right. And basically when we see, yes, they have followed the procedures, they got 75%. However, later on evidence shows that they got the 75% vote for variation through a bribery, okay, because the company actually offered the debenture holders with large amount of shares in the company if they vote for variation. So the company said, we want to do variation. If you vote for variation, we will later on give you a large amount of shares. So this is considered bribery, right? So the company bribed the debentures holder so that they vote for the variation. So in this case, the court disallowed the variation as the vote was not made for the best interest of the whole class of debentures holders. So that's all for today. Thank you very much. Please read books and please feel free to text me in Putra Blast or our WhatsApp group for any question. Thank you very much.